Morning, ladies and gentlemen. Welcome. Today is going to be a fact fun-filled day, and we're packing a lot into it because unfortunately our regulatory body seems to be increasing the requirements. I'd like to thank Bill Holohan, who's coming along to explain the ramifications of the Mediation Act and the effect that it will have on us. Knowing Bill, he will put a positive spin on it, and hopefully he'll show us how we can make a few quid out of it anyway. So the running order really is Bill's presentation will run for the best part of nearly 2 hours. There's a break for lunch. After that, we have a speaker dealing with the money laundering and preparing for a Law Society audit, and that's by Mike O'Reilly. And then subsequently, between 4 and 5 o'clock, Irina Sharakova, who's legal counsel of the Kerry Group, will deal with the new general data protection rules. So it's a pretty intense day, and the situation is that hopefully people will go for lunch and come back as quickly as possible so we can get through it. And there is a welcome drink for people afterwards in the bar. I think last year I was totally overwhelmed. I think all of 2 people who attended went for a drink. So it shows, are we suddenly becoming outstanding citizens? But anyway, so I think hopefully after a long day like today, that people will maybe have one or have a designated driver or something like that. I know Jimmy Lucy pulled a stunt by riding with a crutch, which means I think poor old Mary has to drive him. But anyway, without further ado, I'll call on Bill to kick proceedings off.
John was right about packing things in. Billy Crystal introduced the Oscars award ceremony about 8 years ago, and he said, "Welcome to the Oscars, 4 hours of entertainment packed into an 8-hour show." Now we're going to try and reverse the proportions today. What I'm going to give you today and leave with you, I'm not going to go through every single slide, is the distillation of an 8-hour presentation that I did in Maynooth in January. And it was explaining, what is mediation, how do you actually spell it, what is it, why does it work, how does it work, etc. And the law and the rules and the whole lot. And I was explaining in the course of the morning, in the first session, that with mediation, I don't know how many of you are familiar with it, but we'll give you a quick outline during the course of the morning. I said I usually start with a group hug at the start of the day, and I get everybody together and explain the ground rules and the procedures. And I forgot, you have to be culturally aware, because there was an American in the course, and at the coffee break she came up to me and she said, "I know you Irish people are very friendly, but people who are in conflict, how do they react when you ask them to hug each other at the start of the day?" So I had to go back in after the coffee and explain that group hug was a colloquial expression for just getting together. So I won't ask you to have a group hug before we start. Right, I started this roadshow, as I'm now calling it, back in January, because I offered to do a CPD session, and I figured, it's January, February, 1 or 2 bar associations might actually take up the offer, because it's not November. You're not coming close to the end of the year when you're looking at the CPD points. And then you'll see later on how many have actually packed in so far in the past 10 weeks. But after the first one in Tullamore, I was told that I should introduce myself. So the answer to the question, you're about to get it. I feel like Doug McClure when I pointed this slide. Given that I was here previously actually on the subtopic of insolvency, Doug McClure says, "You may know me from movies such as," when he gets up to The Simpsons, "you may know me from books such as insolvency, bankruptcy, and all such exciting subjects." But I've got, you'll see why I've got all these badges as well, because as I mentioned to somebody just before the kick-off, my mother sent me off to join the Scouts 51 years ago to learn to eat baked beans. And anybody who was watching me eat breakfast this morning will know I hate baked beans. Still involved with Scouts. But like the Scouts collect merit badges, I collect kind of various bits of paper to stick up on the trophy wall. That said, I'm a son of one. My father got his gone to his reward. My mother is still with us. I'm the husband of one, father of 3, and this is the bit that people are intrigued by. I'm the employer of several hundred people. Now, if you look at the size of the practice in the law directory, it's not through that. I'm a shareholder and director of 20 different companies. And I'm not the legal supplier, services supplier to all of those companies. So for a lot of situations, I'm wearing the hat of the client. And what the client wants is they want you to do it faster, cheaper and better. And what I'm hoping to do is to show how mediation in terms of dispute resolution can be faster, cheaper, better. Not just for the client, but there can be a premium for you in it as well. I mentioned already lifelong scout, and the badge is the important bit, because you'll see I picked up a few along the way. After a health episode 2 years ago, and Jimmy was only just saying before we started off that we've all got a bit of mileage at the clock at this stage, we've got to mind ourselves. I was advised I needed to get out more and do a bit of exercise. Now, I always explained that for years, the first 56 years of my life, I wasn't too involved in exercise apart from the Scouts, but that was because my brother soaked up all the sports genes, and he played for Ireland for 10 years. But I took up currach rowing, so that's what I do now on Saturday and Sunday, and when I'm in Cork during the week. Now, when I'm out and about enjoying myself, John Lane is back in the office, and he's the one doing most of the work. They say that you need in any business a finder, a minder, a winder, and a grinder. The finder is the person who gets out there, brings in the clients. You need somebody who enjoys going up to social functions. No truth in the room, you're inviting Gerald Keane to talk about that at your next CPD seminar. You need a minder. Once they get in the door, they'll never leave. They won't go up and talk at a seminar like this. They wouldn't necessarily be up in the Gas Club or the sewing circle or whatever you're into. But once you get in the door, they'll mind the shop. The winder is, you want fries with that. Oh, you're starting a business and you're doing a shareholders agreement, now and after for a limited company, the enduring power of attorney, the will, you want fries with that. And the grinder is the homicidal, antisocial sociopath with a machete you keep in the back room and never let them talk to a client in case they might run screaming from the building. But they're great for doing work. Bit of that in all of us. But John is most definitely the winder. That's just the advertising, the commercials at the start of it, on the basis of the various awards we've picked up. As my wife says, that's great to be picking up awards, but is there any check going with any of it? That's John with his happy face on, collecting the most recent award. We got a special merit award for being one of the Northside businesses of the year. In Cork, like that, some other places, there's a north-south divide. We're one of the 2 firms on the north side of the city. So we got a special mention award. There was another competition obviously for that award. Anyway, I'm a solicitor, notary public, but I'm also an accredited mediator. And I have, again, like the merit badges, I'm accredited by CEDAR, which is the Centre for Effective Dispute Resolution in London. Equally, I'm the MII Mediators Institute, CIAR, which is the Chartered Institute of Arbitrators, and officially now, I'm not just a jack of all trades. As of last month, I'm a master of at least one, because I got a master's from Northumberland University in Advanced Legal Practice last month, so I can now claim to have another badge. The bit about the shareholder, you can look it up in the company's office if you want to. They're the 20 companies of which I am a shareholder or director. Now you'll notice a lot of things like swim and sport in all of those. I like to think that I'm the strategic one. I don't necessarily have to be implementing it and putting it into practice. But there you go. As I say, just known for that insolvency background. But what I try to do now, and what I have succeeded in doing to a large extent, is spend most of my day dealing with 3 different areas of work. The first is ADR, Alternative Dispute Resolution. In other words, resolving things other than through a process of litigation. The second one is professional indemnity and insurance. Now, I don't sleep a lot, which is why John wasn't too surprised when he heard that having arrived on the green bus this morning at about 4 o'clock and checked in, I was up again at 6:30. And my wife doesn't like me being in the bed when I'm awake. So I end up, I don't watch Jalen or whatever's on late night TV, so I end up writing books. That's another one of the ones that I wrote. Hopefully you never get to the need to read one of my books for personal reasons, whatever about professional reasons. But that's one about lawyers' professional negligence. And then representations of colleagues as well. That's something that I enjoy doing. And for example, a couple of years ago there was a colleague of ours from up the west who was most definitely a finder. He was very good at bringing them in, but he never really got a minder and a grinder in the practice. He had a non-qualified staff, and shall we say, there wasn't a great deal of attention to stamping and registration of deeds. Now the Law Society came knocking, as you'll hear how they do it later on in the afternoon, and the report was a bit critical of poor old Dan. Dan was his name. And it went up along the line, but the end result was that there was a lot of stamp duty and interest penalties. This was just after we all went over the cliff in 2008 into 2009. There was over 100,000 euros in interest and penalties due. And there was a chap in Cork those of a certain vintage in the room will remember a chap named Luke in the stamp office in Cork, who was a very forgiving and Christian character, and Luke would forgive everything. Now Luke was so forgiving they closed down the stamp office in Cork, and they moved him into some other area of work. But he forgave poor Dan anyway the 100,000 interest and penalties. And when it got to the President of the High Court, he wasn't too impressed that in a time of financial crisis this had happened. So if you can imagine the scene where steam coming out of his ears was melting the paint off the walls, and he demanded that the revenue solicitor come up to explain why they had done this. Now the revenue solicitor very politely came up and, I paraphrase, offered him a choice of any two adjacent fingers on the one hand moving in an upwardly mobile direction in terms of an explanation on the basis it was none of his business, it was the revenue's business. That didn't improve his mood, and it resulted in poor Dan getting struck off. So, whereas we had a junior who was willing to rock up, quote, out of respect for the court, unquote, to put a semblance of some kind of a monstrous team in the High Court, he had moved on to bigger and better things by the time we came to the Supreme Court 5 years later. And I did the appeal in front of 3 judges of the Supreme Court, and I successfully persuaded them that the President of the High Court had not given poor Dan a fair trial under the Constitution and the European Convention on Human Rights. I had 22 grounds of appeal, that was the first one. They decided it on that, which I was very surprised. They slapped the President of the High Court across the list and sent it back. So I got poor Dan out of trouble, and that's something that I enjoy doing. Anyway, as a result, it's not that I'm afraid of litigation. That's not the reason I'm in favour of mediation and alternative dispute resolution. I've argued cases all the way up in every single court by myself. I even successfully persuaded 3 judges of the Supreme Court, Flaherty, Good Kerry, Barron and Murphy in 1998, that a seat in a theatre or a place of public entertainment in Ireland is not something on which you place your body weight in a sedentary position, i.e. the position in which you all now find yourselves. In law, it's the airspace you displace from the moment you enter the building to the moment you leave. And if you're really anally retentive and interested, I'll explain that over coffee later. And by the way, there's no truth in the rumour he introduced the Court of Appeal just to spoil my record that I argue cases on the way up. I've fixed cases for hearing in the Court of Appeal, not yet. Now, they're operating on what they call the Irish clock. It has one hand, 10-ish, 11-ish, 12-ish. Right. They're a repentant lawyer. I describe myself these days as a repentant lawyer, and I'll expand on that in a minute. This is a photograph of me when I got the Irish Law Awards award for ADR and Mediation Lawyer of the Year. And this was 5 years ago when I was about 2 stone heavier, and that's actually me trying to suck it in to appear thin. So you can see the effect of the rowing since. I'm currently, for another week at least anyway, the chair of the Chartered Institute of Arbitrators in Ireland. I'm a member of the Council of the Mediators Institute, and I'm a member of the Law Society, Professional Indemnity Insurance and ADR committees. So 3 hats. Again, cynical colleagues have said that just because your head is so big. And as I said, I've written a number of books, and I'm currently writing one on ADR, which will be published by the accountants. Now, the moment of conversion. The way I describe it is that for 25 years odd, I worshipped in the satanic church of litigation before converting and seeing the light and converting to the one true church of mediation. And for the past 13 years or so, I felt like the Mormons who will come knocking on your door and go, I have come by Jesus. And the householder says, well, by Jesus you can go. But now people are more receptive, possibly because they have to know about it, but we're hoping that we'll get a few more converts to the cause. So in January, the Act came online on the 1st of January. The rules came online on the 22nd of January. And on the morning of the 22nd, I had somebody, when the central office opened up in Dublin, who went along to try and issue proceedings. And it said, you'll have to file your Section 14 declaration in accordance with the rules. What rules? The rules that came into force today. Oh, have you a copy of them? No. Are they on the court's website? No. Does the department have them? No. So we must file a declaration in accordance with the rules nobody has. Yeah. So I phoned Rosemary Horgan, ex-Cork colleague, our solicitor colleague, and I said, Rosemary, if you don't have them, nobody has them. She did, got them, and the following day I circulated every office in the country, and I should have done that with my left arm. Circulated every office in the country. So somewhere in the mailbox on the 23rd of January, you should have all the rules. And I said, if you're interested, give me a shout and I can send you some information on mediation. Now I got 4 classes of replies. Take me off that bloody mailing list. Second one, yes, please do send me information about mediation. The third one, and I'm keeping the third and the fourth category for suitable purposes of blackmail, extortion, or extraction of some favour at some point. The third one was, please send me information in relation to medication. And the fourth one, not unusually, was information in relation to meditation. Now I responded to all of them and gave them the information and said, if you want me to come down and talk about it, I will. And as I say, I expected, one or two might come up. That, as of last night, was the places that I have spoken so far on this. I've been to the UK to talk about it, and I've been up Sligo, Monaghan, etc. I'm leaving here tomorrow morning to fly to Dublin to get a train to Waterford to talk to them in Waterford. Last night I was up in Wicklow, combination of one speaker, 2 laptops and 3 projectors, and we still couldn't get it to work. God decided that the solicitors in Wicklow deserved a break, so they didn't get it to hear it last night, and we postponed it to some other date. Anyway, here I am, because John asked me to come down. And as I say, I'm off on my travels. Now, the business case. This is from on board SNP, if you remember those good days, about 10 years ago. And they were talking in particular about the Commissioner for Airline Regulation and Dublin Airport Authority spending over $500,000 in public funds on furthering the pension funds of lawyers. Now, I have no objection to the pension funds of lawyers being funded, mine needs a bit, but they were saying it's a complete waste of public money when they could have resolved what was at odds. Now, sometimes you can't resolve things. There's a point of law involved. You need to have a precedent decided, or it's a question of interpretation or whatever. But a lot of cases can. Quotation of a case in England, and this is from the Court of Appeal. And the judge was talking about, what on earth are you doing here? Why didn't you go to mediation? The results were astonishingly good. This in a case which went all the way to the Court of Appeal with over £100,000 in costs involved, over a £6,000 car. Now, a couple of months back, 12 months ago now, Brian McGovern was dealing with a challenge to an award that I gave as an arbitrator, and I gave a punter who had been sold a pig in a poke by a car dealer about €5,500. And you can't appeal those cases, you have to challenge them on some grounds of law. And it was run by a German in Cork who were acting for the motor dealer, and I know the individual, and he said to the garage owner who said, I want to set that award aside. He said, put up 40 grand and we'll start thinking about it. And the garage owner did, because it was the principle of the thing. Brian McGovern nearly lost the plot when he saw his day being taken up to fight over a district court value case. Equally, the judge in the UK in this case said the parties were quote completely cuckoo to have engaged in such expensive litigation. Now, and he also commented on the question of inviting mediation. In the old days, if someone said, will we mediate? It was a kind of a, what's that fuzzy-wuzzy stuff? Oh, they're on the run, they're windy, they have no confidence in their case, they wouldn't be offering to go and mediate. But mediation is only a form of negotiation, it's a form of settlement talks. And we're all well used 3 years to invitations to have a chat to try and sort it out. And again, the courts were saying, look, the results are astonishingly good, you should try it. Now, a partner of Barry Galvin's in Cork came along to talk at a seminar we organised about 6 or 7 years ago in Cork on a user's perspective. And he was talking about having represented somebody in a mediation. And I know I won't identify him or embarrass him by naming him in person, but there's a narrow pool of Barry Galvin's partners. And he got up to speak, and I'll give you his entire speech. He said, you know what, I was very iffy about this mediation lark, but you know, it worked. Got sorted, client was happy, I got a great fee, and he sat down. And that was it. And that's not a bad summation of what the whole thing should be about. So if that's all you want to hear, you can head off and pick up the CPD cert if John will give it to you, but you have to go back to the drink later. Now, business communities. If you go to Australia or New Zealand, the first port of call for business disputes is the local Chamber of Commerce, not the lawyers. And they're well used to sorting things out through there. So here, the Chambers of Commerce 2 years ago decided, we'll try and do the same. And there was a big campaign, there was lovely photographs of the steps of the Hugh Lane Gallery, lovely summer's evening, we all posed, and we got a picture in the Independent, and the Times, and the paper, the Cork Examiner, the Irish Examiner the following day. And there was a panel of 12 wise men and women appointed to hear all the rush of disputes that are going to be coming. There were 3 appointed by the Law Society, I was one of them. There were 3 appointed by the Chartered Institute of Arbitrators, that were precisely nominated. I was one of them, so they had to pick somebody else. The MII, 3, I was one of the 3. For some reason, the barristers wouldn't go anywhere near me, but they're probably a good reason. We've had 0 cases going on through that scheme. This is a quotation from a case regarding personal injuries under the 2004 Act. And again, it said, you know, there's been no root and branch reform. This is the backdrop of where we're coming from. If you ever invite Frank Clark or Peter Kelly to come down and talk about reform, or even Noel Rubottom, who's the director of reform, they'll tell you that the system is creaking. Whatever about fancy new courthouses in Limerick, Waterford, or wherever, the whole system is beginning to creak. They don't have enough judges, they don't have enough registrars, the computer system is now operating on Windows XP, which isn't supported. It crashes regularly. They're afraid the system is going to crash. GDPR you're going to hear about later on this afternoon. After the 25th of May, if somebody's data is compromised in any way, and this can simply be because I intend to send an email to Jimmy Lucy with very confidential information in relation to him or somebody else, and accidentally I send it to Jimmy Murphy. That's a data breach. You have to report it, and as a result, not only can you be prosecuted, you can be sued. Now, Cian Ferriter, speaking with the chief about a month ago in the Law Society, said, imagine the following: Tesco are hacked, and suddenly there's data in relation to customers' shopping patterns. You find out that John Galvin, despite a clean living image and protestations that he only has porridge every morning, he's actually gnashing on the special pay. And he decides he's going to sue Tesco because they allowed his data to be breached. Into the district court, I don't know who your local DJ is here, but DJ thinks this is appalling, that people would think less of poor John like that. 5 grand. Except there were 99,999 other customers whose data was breached. Think now of the Facebook scenario. And how they were lucky all this happened before the 25th of May. 100,000 district court claim notices. The system couldn't cope with it. And that's what they're afraid of. But I'm going to quickly skim through this. Since 2010, they've been looking at reform of the court system. The rules, the procedures, the acts. Frank Clark makes the point that you have 7 different ways of initiating proceedings in the High Court, and that they all have their own separate rules. It needs to be coordinated, slimmed and trimmed. But one of the things that they're doing is they're pushing mediation. And at the various court levels, there are various people who are particularly interested in mediation. And I won't call this the Rhodes Gallery, we'll call it the eminent role. You have the chief up at the top, Frank Clark. You then have Paul Gilligan, newly elevated to the Court of Appeal. You have Peter Kelly, the grandfather of us in terms of the judges, who's now the President of the High Court from the Court of Appeal. Keenan Johnson in the Circuit Court, and our own colleague, Rosemary Horgan. And they're all members of a group called GEM, which is European Judges for Mediation. And they're going to do everything they can to facilitate and encourage people to go to mediation. Next Tuesday evening in the Four Courts, I'm speaking to all the judges to give them a lecture on their powers in relation to the costs, implications of Section 21. And I'll give you the frightening bit about that later on. None of this is new, by the way. It goes back for centuries. The Greeks were doing it. Voltaire has a great quotation there that I'm not going to go through about it. But it all comes from a background of trial by battle. Now, I will buy the first point this evening for anybody in the room who can tell me what do I mean by the right of trial by battle. Because this is, as you've seen from the roadshow, number 16, this is number 17 lecture, and nobody in the 17 lectures has been able to tell me about the right of trial by battle. So anybody in the room who can explain what the right of trial by battle is? I'll do it. It was the right to get the biggest, boldest so-and-so you could get to go beat the proverbial out of the other side, or their champion. And it was decided on the basis that whoever won obviously had God on their side. And that was only abolished in 1819. Now, the gentlemanly way of doing it was pistols at dawn, similar type of principle. Now what do? We have trial by trial. We get into a very convoluted, expensive, grindingly oppressive system of litigation. Padraig Pearse, 100 years ago, described the education system as the murder machine. If he was alive today, I think he'd describe the litigation system as the murder machine. It's grueling for us at the best of times, but for clients, it's truly awful. Toomey J, another one of our solicitor colleagues in the High Court, said that we now have an expensive court system that remains alien and inaccessible to many, and increasingly few. And said things should be resolved collaboratively, if at all possible, by mediation if not, by expert decision if necessary, and only as a very last resort an expensive forum. Monday night, The reason I'm here is I settled the case on Monday night. It was scheduled to last for 8 days in the High Court over a building dispute. And it would have involved quantity surveyors and architects and engineers giving very technical evidence to a High Court judge who probably knew very little about the intricacies of construction. And it might have gone on for longer. We settled it out to the insurance company for one of the parties involved. It was settled for twice what the case was actually worth. But the reason, of course, was to save costs, because the costs of running it for more than 8 days in the High Court, with 4 parties involved, would have exceeded the whole thing. Whereas if it had been by expert determination, it could have been sorted out sooner. In any litigation process, inevitably there'll always be winners and losers. And I'm going to show you how, theoretically, you can have win-win in mediation, whereas you're going to have a win-lose, or maybe even a lose-lose in litigation. It can be stressful, and in this case, the comment was that there was a regret that somebody didn't stop, and that they could have avoided all the costs, stress, distress, etc. limited with it. Irish School of Yoga, this was Lafoy, and she said what was at stake in these proceedings was totally disproportionate to the costs which were involved. In other words, it didn't make sense to be litigating things which could be mediated. Mediation could be offered at a fraction of the High Court costs. You know, last night I got a text from a colleague in Enniscorthy who texted me to say, I'm sorry to God you didn't come down and give the lecture that I gave down in Wexford on the 23rd. You didn't come down earlier because they had a mediator from what I would describe as one of the glass palace firms on the Quays in Dublin. And there was a 5-figure sum charged by the mediator for their efforts in mediation yesterday. But it was still probably a fraction of the overall costs that the case had run. But it was probably double or treble what people outside of Dublin would charge for a mediator. In Walls, again, this was the personal injuries under Section 15 of the 2004 Act. The jurisdiction at that stage was limited to trying to facilitate people, and I'll briefly explain what was involved. But again, the comments were, look, it's highly beneficial, you can settle seemingly intractable disputes. And you'll see in the case law, there was one case in front of Gilligan. It had been a hearing for 150 days, and the plaintiff's evidence wasn't over. They decided to mediate. It was resolved in 1 day. One of our now retired colleagues, Gerald Charlton of Rachel Charlton McKnight in Dublin, had a row with Pat Kenny over a bit of hedge between them. Resolved 1 day. The Dubliners and the EMI records, scheduled for 6 weeks a hearing, resolved 1 day. And most of them are resolved in 1 day. Sometimes it's a long day. The longest mediation I ever had was started at 9 o'clock in the morning and finished the following morning at 4 o'clock. Now, there's a logic behind keeping people in the room. You're all familiar with the buyer's remorse, where you get the phone call the morning after. Oh, I went home and I had to think about it, i.e. I got the head taken off me when I went home for what I settled for. I'm not going to go ahead with the deal. So you kind of keep them there until 4 in the morning. There's no truth in the room where you lock them in and don't let them go to the toilet. But you do try to encourage them to settle while the thing is rolling. And again, strange things can happen. A number of years ago I was asked to mediate in a situation where there were 2 brothers running a very successful company. And there was an age gap of about 10 years between them, but the older brother was the finder, the sales out and about. The younger brother was the numbers guy, and he looked after the financing of the whole thing and the operations. And the younger brother suddenly announced that he wanted to cash in, sell up, and move to America. And he said, look, business is peaked, it's not going to grow anymore, let's top of the curve, let's get out now. Older brother said, what are you talking about? There's another 20 years of growth in this business. Nonsense. They started exchanging memos, getting increasingly tetchy. 18 months later, both had consulted solicitors. Both solicitors had suggested that it be mediated. And myself and another guy came in to try and mediate it with them. Now, the younger brother was in his 40s. And unlike myself, who went the traditional Irish route of getting married after a whirlwind romance of 15 years, this guy got married after a whirlwind romance of about 15 weeks. Himself and his wife tried to conceive. They couldn't have children naturally. IVF failed for a number of years. And he was now in his mid to late 40s. He was looking at the prospect of going to an board of Tala to go through the assessment process, which in Ireland takes between 5 and 7 years. At the end of which there wouldn't be any kids in Ireland anyway up for adoption. The usual routes, Ukraine, wherever, wouldn't be available either. Whereas if you went to the States, where they live with you for about a year, in about 18 months to 2 years, they could have a child in the house. And that was the real reason he wanted to cash in and go to the States. But he'd never told his brother this. Now, they were on the point of bringing petition to wind up the company. In fact, it was a group of companies with very expensive contested application to the High Court. He couldn't tell his own brother this very private piece of information, but he felt able, after one day with me, that he could tell him, a relative stranger to him. And he asked me to communicate with his brother. Now, immediately, the older brother's reaction was, if that's the story, yeah, if it comes to it, I'll set up, and, you know, if that's the reason. I thought there was some business reason for this that didn't make sense. But he said, let's explore the options. Now, what they did do was, they did a bit of restructuring. They freed up money to allow him to go to the States, where he got set up, got into the assessment program over there, remained as a shareholder in the company, remained as a non-exec director, and last year they sold for 5 times the valuation of 5 years previously. Now, equally, if they had sold back in the day, it would have been a fire sale following a petition to the High Court to wind it up, and it would have been sold at a massive discount. So they would have been losers on both sides there, but mediation allowed them to get it sorted. Sorry about this. If I told you that was Queen Mary University in London, as we know, you'd say that he's only trying to impress. But it's the question of when as well. You know, care must be taken not to add complexity to it, another layer of costs. Don't delay, in other words. There have been cases where judges have said, even on the day before the case is to go ahead, would you not try and mediate? But that's usually because there will be huge costs if running, say, a 6-week trial or even a 6-day trial, and there might be a saving. But you have to be cynical if somebody only wants to go to mediation literally the day before the off. And a court shouldn't, in those circumstances, make an order. Equally, you can't be forced to go. You have a constitutional right of access to the courts. You have a European Convention right. Now, judges effectively have the right to say, you're perfectly entitled to walk through the door marked litigation, but before you do, I'm going to send you around the back. You have to read the leaflet about mediation hanging off the back door. You can go in the back door marked mediation, and if it doesn't work, come back out, walk back around the courthouse, and come in the litigation door if you want to. In other words, they send them the long way around. Greatest prospect of success, immediately after the pleadings are closed and issues defined, but prior to expensive and time-consuming discovery. Now, I had a case last year, somebody wrote to a client, here's the letter of claim, by the way, we'll mediate. And even though I'm, as I say, a great advocate of mediation, I wrote back saying, in fact and in law, you have no claim. Please go away. They issued the proceedings, they served a letter inviting mediation. Again, you have no claim in fact, you have no claim in law, please go away. No, please file your defence. Appearance-centred, defence-centred. And when we started the defence, we said, if you now back off, we won't look for our costs. They again invited to mediate. We did go to mediation, but it was on the case of saying, no, you have no claim in fact or in law. Senior counsel, who I know well, wanders in from the other side and said, just for tonight, we'll take 285,000 on costs. And I said, you have no claim in fact, you have no claim in law. By the way, were you briefed with the following? And I started feeding him documents. No, hadn't been briefed with all of this. Went away for an hour, came back. Okay, 85 and costs, and we're done. This is a drop of 200 after an hour. You have no claim in fact, you have no claim in law. Please go away. Goes away again for another while, comes back. Okay, will you pay our costs to date? And again, colloquially speaking, I offered a choice of any 2 adjacent fingers on the one hand moving in an upwardly mobile direction. That was back in September. They left my office that night and we haven't heard from them since. So on occasion, you stand your ground. On occasion, you go to mediation, but your position going in and coming out may be, we're not paying anything. It depends on the circumstances. You might be willing to compromise and suffer the costs of proceedings, if that will get rid of it. That's a cost-benefit analysis thing. And insurance companies, you know, you always hear the punters complaining about the premium being affected because, you know, what they regard as a dodgy claim has been settled. But it's the economics of the thing that will dictate that. But the courts won't make an order as against somebody to go to mediation where they're unwilling. I'm going to skip through these. There's lots of protocols coming in, but it's going to start creeping into other areas as well. What happens is that they dry test it in one area of the law, in this case clinical negligence claims, and then they feed it into other claims across the High Court, down to the circuit, and eventually down to the district. And what's coming is we're going to be ending up in a system like the UK, where you have complete front-ended litigation. Everything is on paper, everything is documented, witness statements up front, expert reports up front. We already had from 3 years ago the obligation for experts to meet, to agree what they can agree, disagree on what they can't agree on, and submit all of that to the court to try and save costs. All of that is going to come even more. Now, mediation is not for everything. You have somebody comes into you and there's a botched kitchen island at £6,000 to put into the house. You're not going to be mediating that unless you're going to set up a cheap and cheerful system between yourselves where you agree you'll try and mediate for a small fee of a couple of £100. You're not going to mediate the Toyota Starlet that's sold for £6,000. Again, because the costs of it will be disproportionate. You might rock on with the district court in those circumstances. But all the rules are going to try and encourage people to go to mediation, facilitate it, require full disclosure up front, etc. You can read through all of these if you're suffering from insomnia. I've got about 100 slides by the way on cost. I'm not going to get through all of those at the end of this, but you'll see those as well. So that's going to be the tarot card for the future. Call it a crystal ball or a tarot card. You're going to have to put all your cards on the table. There's going to be none of this negotiating with cards. Now, there's a certain senior counsel who will be well known in Cork. I don't want to say too much about how he might express himself because it might be recognisable, other than to say his name is John. And years ago, now his standard operating procedure is if you're a plaintiff, come out and ask for twice what the case is worth, and you spend about the first hour trying to get him down to where it's actually reasonable that you might think about negotiating. And after 2-week High Court session plus 1 week circuit appeals, all I wanted to do was go home and put my feet up on Friday evening. And it was about 4:30 and we're set to start negotiating. John comes out and he asks for twice what the case is worth. And I said, John, it's true what they say about you. And I turned and walked away. And he said, what did they say about me? I said, John, it's always the same. You come out, you ask for twice what the case is worth. We spend an hour trying to get down to something that's reasonable to talk about, and then we start negotiating. Could you ever go away, look in the mirror, pretend I'm answering you back, pretend we've had the hour, come back and we'll talk about it? And he was so flabbergasted, he did drop to the reasonable zone straight away. And you can't do that every time though. But that's where you know who you're negotiating with. But if you're dealing with some po-faced senior counsel that you've never met before, or junior counsel or solicitor, and you don't know whether they're bluffing, you don't know how to test the metal. You probably all know each other very well. You know when somebody's bluffing. You know the ticks that they have, like playing a poker game, and you can negotiate. But if you don't know what the form is like, you might not. All this on the cards and the table stuff is going to go away with all of that. Now, a question which was asked this morning. Does ADR stand for something other than alternative dispute resolution? Does it actually stand for alarm and drop in revenues? It's a different lecture, and you can get somebody down from the Law Society to give you the shampoo lecture, as I call it, the science. But we're all familiar with the idea of the big fee, the 1 or 2 huge case fees that lands every year, and we're delighted. It will all go on the proverbial when we get something like that in the door, particularly if it's coming up to pay the tax on it. But the reality is that's actually cross-subsidising a lot of what we do. We do a lot of pro bono work. We do a lot of under-remunerative work. And if we actually got paid for every hour we did put in, we wouldn't have that kind of problem. And the big fee that landed in would actually be the icing on the cake. It would be the pension fund. But the economics don't work out that way. And as I say, that's a different lecture, but you should get somebody down to do it from the Law Society, because it's alarming what you actually find out. But we had when the Act was passed in October, we had a session, organised a joint session with the Chartered Institute, the Law Society and the MII. Curiously enough, my involvement in all 3 facilitated the organisation of that. And somebody asked the question, is it going to be an alarming drop in revenues? Anthony Hussey Fraser, if any of you know him in Dublin, who's a big construction disputes lawyer, arbitration man, he said, yeah, probably. And everybody in the room rounded on him and said, absolutely not. The reason being that if you can get the reputation of being the person in town who can solve something in short order and get a result to the client that they're happy with in 6 days or 6 weeks or even 6 months rather than 6 years, you will become the popular man in town. Now, I googled for popular women, but I couldn't use any of the images that came up for popular women. So I'm just squeezing, just putting up the popular man. But we'll take the example of John Galvin, who suddenly converts to the Church of Mediation after today, and he starts mediating the bio, and he starts getting results for people in 6 weeks. And it can be done. Everybody says he's the man to go to. Forget that man. You know, he'll have been in the court for years. John's the boy. You can do the gratitude curve billing. Now, the best example of gratitude curve billing I ever experienced personally was the following. I mentioned the insolvency earlier. I also did, when I was doing my apprenticeship, I did an LLB down in UCC. And I did it on the exciting subject of limitation of liability under the Merchant Shipping Acts 1894 to 1981, a subject that now you're all intimately familiar with, so I won't mention it anymore. But as a result, I got involved in the Irish Maritime Law Association, and I'm still there on the committee after 35 years. Every year I resign and they say, no, we need somebody from Cork. So you fit the bill, literally. But guy was dealing with a Glass Palace firm in Dublin. He was on to the insolvency department, they couldn't answer his question. He was on to the maritime department, they couldn't answer his question. So in desperation, he Googled insolvency lawyer plus maritime lawyer, and he got me. And the question was this, he says, I'm the CEO of a shipping company. We're shipping a container, it's a very valuable cargo. The company for which we're shipping it has gone into examinership, and the examiner is saying, I can't take any action or enforce any rights in support of our claim for the shipping charges. And I said, there's a very technical legal expression to describe the answer to that proposition. It starts with B, it ends with X, there's 2 vowels and 2 L's in between the B and the X. I'll leave you fill in the gaps if you're a crossword enthusiast. I said, you have a shipper's lien, and it's like a solicitor's lien. You don't have to take any proceedings, it just exists. You announce that it exists, and it's there, it's effective. You don't have to take any action, you're not prohibited under the Companies Act from doing it. The result, they went into the court, the examiner went into court for what's called a Section 10 certificate, and that's usually to keep the lights on and pay the ESB. But in this case, they applied for a Section 10 cert for €175,000 to pay to my client, which was the bulk of what they were looking for in terms of the shipping charges. Client absolutely delighted. Now I explained, if the scheme succeeds, there'll be a dividend, you'll get a percentage of the balance that you owed, it'll come through. 6 weeks later, in comes 10 grand, which was the percentage of what the balance of what they owed. Rang the client and said, look, they've made a check out to me, I'll run it through the books, I'll send it on to you. What are you talking about? And I explained again, this is the icing on the cake, the extra little bit above what we got. He said, oh, I ruled it off here, I closed the book on it, I thought it was all done, I was just waiting for your bill. But sure, look, your bill will be 10 grand anyway, wouldn't it? And I said, well, no. I said, on the clock of under 2 grand, you might be used to having those kind of bills from Glass Palace firms, but my office in Dublin is up near the forecourts, it's in D7. So I said, I don't have commercial clients. The commercial clients south of the river, we have business clients north of the river in Dublin. And he said, you keep the 10 grand. He said, I'm delighted with the result. You sorted it out. The Glass Palace firm couldn't do it. I'm more than happy. Now that was a case of being able to bill at a rate of about €2,000 an hour. Never happened before, will probably never happen again. It'll probably be so unusual they can put it on my gravestone. But it's an example of gratitude billing. That if you hit the client at the right time, when they think you're the baby Jesus, Mary and Joseph all in the one, and the Holy Trinity to boot, they don't care what they have to pay at that point in time. Leave it 6 months, you might have a problem. And I'll explain in a minute why you shouldn't leave it too late to give them the bill. But that's the example of gratitude billing, and mediation to put you in that space. When to do it? There's no right time, there's no wrong time, you just need to think about it. Not every case is suitable. I've already mentioned the Kitchen Island and the Toyota Starlet. It will more than likely be other cases. Succession cases, 117, family disputes, even commercial disputes, they're all very suitable. I'll give you another quick war story. A couple of years ago, a bank rang me and asked me, would I, at their expense, mediate a dispute? Now I thought this is a customer-bank dispute. I thought, you know, geez, that's radical enough for a bank to be thinking about mediating. Normally they litigate the proverbials off people. It wasn't between the bank and the customer. It was between the customers. There were 4 brothers who had been taken out of school at 14 to go into the family business, which was 8 up to start off. Started in the cellar, worked their way up. By the time the father, who ran the business, died, they had a chain of pubs. And the 4 had served their time. So the father thought he'd leave the business to the 4. The only issue was, there was a gift from God, 15 years younger, in the form of another son, the 5th son, who was the apple of his mother's eye, and who, in the opinion of the 4, was a spoiled pup. had been given the university education, had decided to go to Maynooth afterwards, didn't stick with it, came out, got married, started up 3 businesses which had been bankrolled by the parents, all of which didn't work out. Now the brothers had a theory that it was due to a lack of application on the part of the brother, but I don't know, didn't have a crystal ball to go back and look at it. But the father in his wisdom, when putting together the will, decided he kind of has got a bit of an advance on the inheritance in the form of the subs for the first 3 businesses. So he got a modest amount. All of this preceded the events that I'm going to describe in terms of the mediation. But before the father died, he persuaded the other brothers to get involved in the business. He said, I've identified a great premises north side of Dublin, and we can put a creche in there. There's no creche for miles around. Guaranteed business. We've got a tenant lined up, and got onto the mammy first. The mammy put the pressure on the 4 boys, and they all signed up. What he didn't tell them was that the lease was going to be a non-FRI lease. There was going to be no rent reviews in the first 15 years. The tenant was a company controlled by his wife, and the terms were very favourable to the tenant in lots of other ways as well. So that, when all that fell out afterwards, it didn't endear good relations between them. The father died after all that had been set up, and the son, the 5th son, the gift from God, decided to take a 117 action. And again, for the sake of the mother who was still alive, they cut a deal with him. So family relations weren't that great going into all of this. So, you know the idea that when people are having a row, there's an elephant in the room that nobody wants to talk about. In this case, there's a herd of elephants outside. There was a rake of other issues, including the fact, and it explained why the bank were willing to pay me to sort it out. A solicitor had given an undertaking to put a mortgage in charge, and there was no mortgage ever put in charge. He was actually one of the best customers of the bank branch, and they were faced with having to sue one of their best customers. So if something could be sorted which would get him off the hook as well, they were more than happy. Equally, there's a rake of other issues involved as well, all of which kind of went into the mix. The bank were willing to pay for it because there were 2 loans drawn down. The first one, everyone said, yeah, we all signed up for it. The second one, 2 of the brothers said, never heard anything about a second loan. 2 of the other brothers said, yes, that's our signature on the mortgage documentation, etc., but we knew nothing about it. We have a memory of them coming in the middle of the lunch while we're carving stuff for customers, saying, I'm off to the bank, I need you to sign that. And we signed something, and it's probably that, but we never agreed to take a second loan. So the bank was having a row with the customers in relation to that as well. Now, I won't bore you with the story of the day, but they said he's a young pup. The young pup, by the way, at this stage was 52. He'll get up and walk out on you at some point. And sure enough, he came into the mediation when we broke up from the group hug and went in. He threw down a piece of paper and said, they're my terms, unless they sign those, I'm out of here. I said, well, can we talk about them? No. And he got up and he stormed out. And I rang him after a couple of minutes, and I said, Brian, that was his name, Brian. He said, have they signed? And I said, no, they haven't signed. Click. So I left another 5 minutes, and I rang and I said, Brian, now all I could think of was, how would I deal with my 15-year-old stroppy middle fella at home? I had 3 boys. And the middle fella was 15 at the time. How would I behave with that behaviour with the 15-year-old? Because that was the usual behaviour from the 15-year-old at the time. So think this 52-year-old is only 15. I'm very sorry, Brian. I obviously offended you in some way. No, you didn't offend me in any way. It's then so-and-so's in the other room. And I coaxed him back in. Now, it took a while to get him back into the process. He knows he had to go off and do a message for half an hour. Don't ask me, I never found out what he had to do. He said he had to go off for half an hour. And you know the fellas on the stage who keep the plate spinning? I had to go back into the room and keep that plate spinning with the other crowd. But the following day, the bank manager rang me and he said, can I ask you something about yesterday's mediation? So I'm sorry, it's all confidential. I can't tell you anything. So now Brian is here. He's trying to finance the deal that you structured yesterday. I just want to know, did you use hypnosis, drugs, or a shotgun? Because I had no faith in that thing working out. So even something where people won't even talk to each other like that can be worked out. Anyway, premature mediation can waste time. If you go in too early and you don't know what the issues are, it won't get sorted. So identify the happy medium. I mentioned that case already, 150 days of hearing. Now, this is an important part. Like Brian, I'm very interested in what makes people tick, and equally I'm very interested in what makes people tick. And my mother has an expression that I quote at least once every single day, and that's it. And even if you never get into mediation, if you're in litigation, if you're dealing with conveyancing clients, if you're dealing with any kind of client, psychology and understanding people is a fascinating thing. Well worth your while getting into it. But the process of mediation is about understanding where people are coming from, what makes them tick and what makes them tick. Anybody read this book? I'd recommend it, even if you're a litigator and a negotiator. I'd recommend you read it, because it's a great one. Orange Kernel. Anyone ever seen this before? It's usually one. Okay. Courthouse, lunchtime. John has very kindly provided fruit, because he figures no one will eat it. The biscuits, they'll be gone in a minute, but fruit will last. Except in this day, there's only one orange left. 2 practitioners, one male, one female, both in the bar room at lunchtime. They both die for it. They both touch it at the same time. Both say, I want it. Now, what's the maximum result that each of them can achieve? What is a vague whisper somewhere? Go on. Half. 50-50. Is that the best they can do? Okay. Alright, so you think. And each is safe in the position they each want it. But what do they actually want? She's a Doreen fan. She just wants the skin to put an orange zesta cheesecake tonight. He's a man, he prefers a bit of steak. But he can't get it. He has to hang around the courthouse. He goes for what's available, which is the orange. He doesn't want the skin, he just wants the orange. They can actually have 100% of what they want, but they don't know it because they haven't actually shared the information with each other. Now, classical approach, you divide it, you split it. If you had a mediator, if John came in and says, you know, lads, that's what he's having a row about, and because he's now the popular man who mediates everything, he decides to volunteer to mediate the dispute. He's like Humpty Dumpty sitting on the wall, except he has more hair than Humpty Dumpty. But like Humpty Dumpty, you get to see both sides of the wall. You see what the story is. And if people level with you, and they tell you what the real issues are, they tell you what the drivers are, they tell you what their concerns are, like the younger brother who said that the reason I want to go to the States is so that I can have a child, as I think for some business reason winding it up. You can, knowing what the full story is, you can see if there's a middle ground between people, and you try and guide them towards it. So John finds out what the story is, and lo and behold, he keeps up his perfect record of mediating every dispute by giving the skin to one and the pulp to the other. Now, that's a simplistic example, but there's actually a science to it, which results in the win-win for all concerned. If you look at John Nash, the author of A Beautiful Mind, the subject of the film as well, he actually did a master's thesis in relation to the whole thing, and he's proved that if you cooperate, you can actually maximise the results and the benefits, because a lot of stuff gets consumed in the process, even in terms of the costs. When I'm sitting as an arbitrator, and I do a lot of that as well, I explain that there are 4 versions of what happened. The first one is what the plaintiff says happened, the second one is what the defendant says happened, the third one is what may actually have happened, but the fourth and most important one is what the judge or the mediator, or sorry, the adjudicator or the arbitrator decides happened. And the last one may not fit with any of the other 3, and it may not make the parties who are involved happy because it doesn't go that way. Equally, if you think about it, prolonged litigation is a very expensive inquest into the past. And what you try to do is you try to blow holes in the other side's case, in their credibility, in the strength of their case, recollection, and remember, people misremember things. And if they're proved to be wrong in the way they've remembered something, then it undermines their credibility. Last week, a senior counsel told me that he had witnessed a fatal accident. He had seen somebody killed right in front of him, and he gave a statement to the guards. It was a road traffic accident, and he gave a statement to the guards, and he was asked to come back and amend his statement. The reason being, this senior counsel, whose name would be known, he's originally from this county in fact, he got the make of the car wrong, and he got the colour of the car wrong. Now, that's a man who's used to detail, and 2 fundamental elements of it he got wrong in his statement. But I always say, let's not dwell on matters historical, lest they become matters hysterical. The process of litigation is destructive. You go and get your shopping list, and you might have a bucket of ice cream on that, and let me tell you from experience, a bucket of ice cream is not good for your waistline or your health. But you have to give it up, and when you're giving up to get a settlement, and you're coming down, it's a negative process. Psychologically, consciously or unconsciously, it's a negative process. With mediation, your starting point is, what's the minimum you need to come out of it here? What can you live with? And you build up on it. It's actually a positive process. Won't bore you with the science of it, again, but if you look at the book, it's in there. Apologies. Did somebody mention an apology earlier on? No, it was in Watergard, Wicklow last night. Imagine the scenario. If senior counsel stands up at the start of the case and says, at the outset I'd like to apologise to Mr. Gelman for having called him a so-and-so and a fraud and a whatever, completely wrong for having done so. Other side will be up straight away, judgment and costs, please. You go into mediation and the whole thing is confidential. And if somebody goes up to John and says, John, I owed you more respect than I showed you. I'm sorry, I called you bollocks, you're not. I called you a fraud, you're not. You deserve better than that, and I'm really sorry. It's not that I agree with what you're looking for, you deserved more respect than that. A lot of emotion goes out of it, a lot of the fire goes out of it, and you can start moving forward. You can do that in mediation and it doesn't come back to bite you, because unless there's a deal done, it's completely confidential. Equally, remember God gave you 2 ears and 1 mouth, and you should try and use it in those proportions. Then you listen to understand. Part of the process is making sure that everybody understands where the other side are coming from. And you don't have misunderstandings. I won't do it on camera, but if anybody's interested, I'll tell you a story about where somebody very nearly got themselves into a very embarrassing position that could have got them struck off, all over a misunderstanding of what was actually said in a very noisy bar environment. But people misunderstand things. And the idea of mediation as well is that you get to understand where somebody is coming from. And once you understand it, and you have a different perspective on it, you can move forward. Stephen Covey, 7 Habits of Successful People. There's always at least one person in the room who has heard of it, but actually claims to have read it. So who's the person in the room who claims to have read it? I'm not going to ask you any questions about it, just, there's always, no. Very brave to that you haven't. Stephen Covey talks about changing the paradigm, and he gives the example. A guy gets on a tube train, or the Dart, or whatever, in an Irish context, has 2 kids in tow who've obviously been fed on Smarties and Coke all day, and they're bouncing off the walls. They're annoying the proverbial of everybody, and eventually somebody snaps and says, would you ever control your kids? And he looks up and says, I'm sorry, my wife is dying, I don't know how I'm going to tell them. Now in the book, out come the colour and pencils and crayons or whatever, now to be the iPad or the iPhone to try to amuse the kids. But it's changing the perspective, understanding the situation of the other party, where they're coming from, what's motivating somebody to bring a 117 claim, what's the real reason behind it, that type of thing. And the process of mediation allows that to happen in a non-threatening environment. Equally, in the course of the day, not that you keep them there until 4 in the morning, but people find it a very exhausting process. And if they think that mediation, which is a kind of a safe environment, is wearing, stressful, you hold up the prospect of litigation to them afterwards, and they say they don't want to go there. Now, I'm not going to bore you anymore with what the mediators do. You can read that in your own time. And as I say, if you have a insomnia problem, that will cure it for you. The question is, what's the lawyer's involvement? Before mediation, and we're going to go through the Act and the rules in detail, you have the duty to advise, give independent advice, attend the mediation. In the mediation, your role is there to advise. It's not to act as an advocate. Brian McMahon, the native of this county, gave a great lecture a number of years ago to the Chartered Institute about the art of advocacy. And he was talking about how you can have a terrible case, but someone can make it sound brilliant. You can take a pig's ear of a case and make it sound like a silk purse. And the way he said it was, you listen to the counsel for the plaintiff, and you think, my God, she's right. And then you listen to the counsel for the defendant. You think, my God, he's right. This is very important at that point in time to think about the little voice in the back of your head saying, cop yourself on that, they can't both be right. Now, mediation advocacy is a completely different thing, because you're not trying to persuade a judge, you're not trying to persuade somebody who's going to decide. Your mediation advocacy, you're trying to persuade the other side that you're right. And in an opening session, your gambit as an advocate or a representative of a client should be to persuade the other side that they have something to think about, so that when they go back into their own room, it's not that they're saying, we told them, we showed them how, that they're saying, holy God, no, they might have a point there. If you're particularly interested, there's a training course being organised by the Chartered Institute coming up in May. Now, we're having a difficulty finding a venue, and I've put forward that we do it in Horse and Jockey, because I was down there for a lecture as well, and the facilities are great. So the first one may be in Horse and Jockey if you're interested in that. And if anybody wants to go beyond and become an actual mediator, there's a training course being run in May as well. It's a 5-day course. More information afterwards if you're interested. The process, you normally, as I say, start off with the joint hug, and you break up into separate rooms and you shuffle backwards and forwards. And you get concessions from people, and you say, well, if you can get this, what are you prepared to give in return? And the art of it is making people think that they're the generous one. So you tell me you're prepared to give something. And I go and I say, well, if I could get what I know I've already got, what would you give? And he says, Grand, I'll give you this if you can get that. And then you make each think that they moved first. They're feeling good about the process. It starts a roll, and the whole thing starts to fall into place from there. It's the psychology of the whole thing. What's been happening? I'm going to give you about 5 minutes on this. Before the Mediation Act itself, we had the traditional Irish response to a problem. Whenever we have a problem in Ireland, we stick a sticking plaster on it. We don't stand back and decide, do we need a new bolt? We just put a bit of tar on the cork or a sticking plaster on the side of the door of the car or whatever it is. So we have various court rules, and now we have the Act. In Dublin, you have a mediation project in the family courts. If you go in to issue a barring summons, maintenance summons, custody issue, they say, we have mediators upstairs, do you want to go up and talk about it? And over 60% of all cases in Dublin in the family courts are now dealt with through the mediation system. And there's all sorts of new methods. There's an EU directive in all of this, and that's led to changes that have fed through all the various legislation. Outside of litigation itself, it's featured for a long time in employment law, and you've had employment disputes and workplace relations issues have been mediated. And years ago, when they were consolidating all of this, the government services and the retrenchment, and Charlie McCreevy's great devolution plan was being rolled back. There was a guy came in from one of the trade unions from Mandate, and he gave a great talk about workplace mediation, which is a real Wild West territory. But our family law was bad. Workplace can be even worse. And he gave an example in the Midlands of 3 VECs that were being amalgamated. And suddenly now they all had to go and work from one location. 2 VEC offices had to travel to work, which they didn't have to do before. And there was a rule that if you had to travel more than 28 miles, you got a bit of subvention and a few bob in your pocket to travel. But if you were within 28 miles, you didn't. And of the 2 offices that had to travel, 1 was within the 28 miles, 1 was without 28 miles. So immediately your people who are working side by side, one of whom is getting paid a bit to go to work and the other isn't. Then he said, it can be the simplest of things can cause a row. He says, the crowd from office number 1, their story is the whitest, greyest haired person in the room, i.e. the eldest serving, first dibs on holidays, right? You're up for it. Office number 2 is the fastest to the sheet to sign up for the available holidays. Office number 3, it's a lottery. You draw it out of the hat. You now have 3 different cultures, all of whom say, that's our established working practice, they're the conditions under which I'm employed, and stand back and wait for the row when holiday time comes around. And equality law, the director of has that as well. The landlord and tenant disputes, I served 6 years on the then entitled Private Residential Tenancies Board, and I did over 300 cases during that time, either adjudications or mediations. Now, I only ever did 1 mediation, the reason being the parties have fallen out, the landlord wants to keep the rent, the tenant wants the rent back, or the landlord is claiming because they left the place in terrible condition. There's no relationship there for the future, there is no common future, therefore there's no mediation. It's into adjudication. I had an interesting experience when I turned up I was also on the appeals tribunal, and that's 3 people. I turned up to the G Hotel in Galway and asking at the desk, just like I asked this morning outside, what room are we in? And this guard in riot gear arrived over, and he said, are you the tenancy people? And I said, yes. And he said, we're here. And I turned around, there were 2 more than full riot gear. And I said, what do you mean you're here? And he says, oh, we're here for the hearing. And why are you here for the hearing? You haven't heard about the tenant, no? I said, no. And he said, don't worry, we'll be in there. And when they came in, they put on the helmet, they strapped it off, and they took the batons out, which was very encouraging start to the hearing. The man behaved himself, mind you. Debt collection, after the Monaghan Credit Union in 2009, where they jailed somebody and it was all declared unconstitutional, they introduced a provision allowing for mediation of debt collection. But again, hasn't happened. Who's going to mediate a €1,000 claim in the district court where you're looking for a tenner a week? There's nobody paying for it. I suggested to Rosemary Horgan she should get on the retired DJ who'll be well used to it and who's husbands and wives respectively might be kicking them out in the morning, saying go away and annoy me for the day. That they might get them to do it, but there's a sourcing issue where who's going to pay for it, insurance, but they're working on it. I was inspired by that because my father retired at the age of 55 with no thought of retirement. He got a package in Arietta, and at the time, because of all the levies he was paying, he was going to be £18 a week better off in 1985, retired, than working. And after 3 weeks I asked my mother, how are you getting on with the retiree? And she said, I now understand why you read stories in the paper of happily married couples where the wife will suddenly sink an axe in her husband's head, get him out of the house. So, equally the retired ages. First off, commercial court rules, you could adjourn and encourage people to go off and do it. Only apply to commercial court proceedings, only a power to adjourn, no power to invite, no power to offer information, no cost implications. If somebody said, no, I'm being bolshy about it, I want to go ahead. Civil Liability in Courts Act 2004, mediation of personal injuries cases. Has anyone in the room ever mediated a personal injuries case? I've mediated one as mediator, but has anybody been involved? There you go, doesn't happen. Mediator, a person agreed or appointed by the court, practicing barrister or solicitor, or a person nominated by a body prescribed. Now, in addition to all the bodies already mentioned, there's a group of us in Cork, commercialmediators.ie, and since 2007 we've been trying to become a body prescribed. And the initial letter went in 10 years ago, and every 6 months the reminder goes out to the department, and every 6 months the standard reply comes back. The matter is under active consideration. Yeah, really. Confidentiality, all matters dealing with the mediation are to be entirely confidential, and no records kept, evidence can be given. Costs paid equally. Only applied in personal injuries actions, no court initiative. The parties had to make the move to go for it. It favoured loyal mediators, no cost guidance on it. Having heard from the judge may request the creditor and debtor to seek resolution. And just to go back for a second, the lawyer mediators, it's not necessarily always lawyers who would act as mediators. What you need in a mediator is a good, empathic mediator, somebody who can build a relationship with the people, get them to buy into the process, get them to move towards a settlement. I'll give you an example. I mentioned that I do professional negligence work. I was acting on the instructions of an insurance company for an insurance broker. Insurance broker approaches builder's labourer and says, you are having a health insurance package with a certain company, we can get you a better package with more cover, at less premium, and get your wife included as well. Are you up for it? Job on, yeah. The broker said, look, it's the 29th of the month, we'll sign everything up today, but your premium is paid on the 15th of the month. So what we'll do is, rather than have double cover for 15 days, we'll cancel the old policy as of the 15th, and we'll start the new one on the 15th. So actually, you don't even need to cancel the old policy. Just don't pay the premium. The insurance company will write out to you, and let 2 premiums lapse, the policy will lapse. And meanwhile, the new one will be up and running. He says, I'll hang on to the paperwork, you don't have to worry about it. That was on the 29th of the month. 5th of the month, your manager work hits the deck, goes to hospital, subsequently diagnosed terminally ill. Old policy lapses because he didn't pay the premium, because he cancelled the standing order. Old co off the stage. New co doesn't hear anything about it for about 6 months when the claim goes in that he's now terminally ill. And they say, stop the lights. On the 5th of the month, when you hit the deck and you were carted off by ambulance, you should have notified us. Now, he had other things in his mind, and so did the wife. You should have told us about this because this was a material event. As far as we're concerned, there's a material non-disclosure before the inception of the policy. We're not paying out. Result, High Court proceedings issued because the value of the policy is hundreds of thousands. Proceedings issued against the old insurance company, the broker, and the new insurance company. 3 sets of legal teams with junior, senior counsel potential for hearing. And I was acting for the broker. There was an in-house solicitor for each of the 2 insurance companies dealing with it. And I had a job of work to persuade them that we should mediate it. I said, this guy cannot lose. He's dying, he's going to go in front of a High Court judge, and you identify any High Court judge who's going to fight against him. As far as he's concerned, I did nothing wrong, somebody screwed up, somebody has to pay here. Old Co said, look, it's really nothing to do with us. We did nothing wrong. Nobody told us anything about this. The policy lapsed because the premium were unpaid because of the standing order. We'll pitch in a modest sum. So it's really down to broker and new co. And I said, look, we can clock up 50 grand each minimum costs. We can buy the claim off for about that kind of money. So what do you want to do? Have the case, have 150 to 200 grand costs for a 3-day hearing, and I've summarised the facts for you. That's what it was, but there's nothing so simple a lawyer can't make it complicated, so we would have had a 3-day hearing. Let's mediate. Eventually they said yes. We obviously need a senior counsel mediator who is an expert in insurance law. Now again, you heard me describe a certain legal proposition earlier with a response starting with B, ending in X, 2 L's in the middle and starting by 2 O's. I said, no, we need a good mediator, somebody who can bond with this guy and get a good mediation process going. And eventually there was compromise on one of my predecessors in office as the chair of the Chartered Institute, who was actually started off life as an engineer. Had nothing to do, had no legal qualifications, apart from being a fellow of the Chartered Institute. I also said in terms of managing the process and understanding how it works, I said, we need to have mediation before and thus. Telephone mediation, letter mediation, however we do it. But on the day we arrive in to talk to this guy, we have to have an offer ready for him. There's no way we do it in the morning, it's grand, it's grand. Now we had it in the Vienna Woods Hotel outside Cork City, and on the morning I understood why they were so reluctant to come and have a discussion beforehand. Because there were 10 people who arrived in for the Luco. They had reinsured, they passed on the risk to others, and the others were coming into the picture as well. We spent from 10 o'clock in the morning until 5 o'clock in the evening working out what we were going to offer the dying man in the room next door. And by the time we went back, the wife, and I again paraphrase, you've heard me now for about 3 times, offered a choice of any 2 adjacent fingers in the one hand, moving in an upward mobile direction, said, I don't care what you're offering. I'm going to court, I'm going to tell a judge the way you behaved. Now she couldn't because it was all confidential, but the end result, we settled about 6 months later when the guy was almost dead. I mean, it settled only because the guy was about to die. And his part of the claim might have died with them to a large extent. But again, it was at a huge 50% increase on what we could have done for on the day. So managing the process, managing expectations, and understanding how it works is all important. Anyway, enforcement court orders I already mentioned, circuit court rules, case progression hearings, all the shortcomings are there. I'm going to spin through these. Then Order 56, which is the High Court rules, it applied to every set of proceedings in the High Court. It then had the cross-border directive. They could have applied it to all disputes. So if you order something from Amazon in Slough, or Reader's Digest in Oxford, or wherever they are, this will govern it. They could have applied it to ordering something from Dunshaughlin in Dublin, or from Gwillimbulla in Kerry. They didn't. Again, shortcomings of all of that. Whether it was enforceable or not, the extent to which it was, and how it was done, all governed by the rules. I'm going to skim through those. The statute of limitations, under the relevant provisions, the statute of limitations stopped. Now, wearing my lawyer's professional negligence hat, as the author of the book, I tell you, do not rely on the statute. The 4 brothers who came up from the cellars had the proceedings, and they showed me on the day at the start of the mediation. They said, if he runs out the door, we're going to go after him. At this stage, we don't care about the mother. We're going to crucify him. We're going to bury him. So that's why I had to keep the plate spinning, because if they knew he left, they'd have gone after him. The whole thing would have fallen apart. But the statute stops. Wearing my professional negligence lawyer's hat, don't rely on mediation. You don't want to be caught like in the snow where somebody rings you from, a client from Monaghan, rings you in Kerry on the last day of the statute to tell you that they have a claim they've been meaning to get onto you out, and you can't get the thing issued. So the county registrar has seen fit in the midst of a snowstorm to send everybody home at lunchtime. You don't want to get caught like that. So if you have a statute problem, issue it, keep it in your back pocket, and you can worry about it afterwards. The Muds Act, anyone here had a claim under the Muds Act? No. I'll just give you 2 minutes on it. The reason being is that you can't go in for a claim under Section 24 of the Muds Act. That's the Multi-Users Development Act, in other words, multi-tenanted or occupied buildings, unless you have previously tried to go down the mediation route. And the court is entitled to get a report from the mediator. Now, there's an important distinction between the Muds Act mediator's report and a Mediation Act report. The Muds Act report, the mediator is entitled to say him. He played silly buggers in the mediation. And that has cost implications. I acted for a party who went to a mediation. There was a contractual clause that the parties had to go to mediation for a minimum of 8 hours before resorting to litigation. So it's called an escalation clause. They didn't, they went straight into court. We applied to Peter Kelly and said, contractual obligation, like arbitration, contractual obligation to go to mediation for 8 hours. Now normally there's no compulsion, but here there's a contractual obligation. He said, you agree to do it, off you go. I paraphrase. They took off the watch, put it down, crossed the arms and proceeded to sulk. And for about 2 hours, a very good mediator tried to get them to chill a bit. Nothing doing. The mediator said after 2 hours, I'm shutting down the mediation and my report to the court can reflect that I decided after 2 hours there was no engagement by one of the parties. Now, it was very much a case of going back to Peter Kelly and saying, Judge, we're the ones who wanted to go to mediation. The mediators tell me somebody was playing silly buggers, join the dots, and he did. And the report, as I say, if it was a Muds Act, it wasn't a Muds Act in that case, but the Muds Act, the mediator can point the finger and tell the judge. Now that has implications in terms of costs that I'll expand on. And you have to explain if the mediation took place, what happened, if it was settled, what were the terms, etc. The Personal Insolvency Act, there's only about 5 PIPs solicitors in the country. I don't think there's any, no, there's none in Kerry. Brian Leslie in Killarney is a PIP, he's not a solicitor. But there's a provision for mediation of complaints against PIPs. And there was one of our colleagues, a solicitor PIP, was consulted on one day and the complaint was did the following day, basically because he didn't like what he got to hear. The debtor was very disappointed to find that the solicitor PIP wasn't going to say, oh, we can have all your debts forgiven. He had a misunderstanding. The complaint didn't go anywhere. But equally under the Legal Services Regulation Act, the Law Society at the moment deal with the complaints. When the Act is fully up and running, the regulator is going to be dealing with it. And any complaints will go in there. They'll be favouring mediation. Now at the moment the Law Society, if anybody has had the pleasure of a complaint having been made against them, and if those who've never had a complaint against the Law Society, please raise their hand, or against the names of the Law Society, please raise their hands. Yeah, there's nobody in the room who's never been complained. We've all been complained by some new client at some point. But the Law Society play ping pong with the paperwork. They send it backwards and forwards, and they don't try and resolve it. They try and wear people out, but it doesn't really work. The regulatory authority are going to try and mediate it. How many of you are aware, and this is the gratitude curve point again, that under section 152 of the Act, when it comes up, you have to say to the client, here's my bill, you're entitled to have a row with me about it, and if you do, I'll mediate it. What do you think the result would be if you're 6 months down from the gratitude curve when you do that? You're going to have, you're telling them, you have a statutory obligation to tell them they're entitled to have the row. They will have the row, and you will end up losing. You lose on the fee, you lose on the time in getting to a result on the fee. So, back to the gratitude curve. Even if it's not, if you don't mediate, always try and get the money up front if you can. If you can't, make sure you get it when the gratitude curve is at its highest. Years ago, just after I qualified, I started out with something for somebody, and I said, good luck and I'll see you again. And he said, Bill, I never want to see you again, unless it's over the head of a point. Don't you realise you're a grudge purchase? People only go to lawyers when they're in the proverbial. And it's a valuable lesson to learn. So if you can get them into the gratitude curve, build them. And again, you must advise somebody that they have the option to mediate with you. Legal costs, the tax system. There were 2 taxing masters. One was less productive than the other and resigned. Paul Bean has stepped in, but that all coincided with the Kerr decision, which says now that if you have a claim for costs in from Jimmy Lucy, and there's a claim that he spent 4 hours at the photocopier on a Sunday night, the question will be asked, why, with a bad hip, was he standing at the photocopier for 4 hours on a Sunday night? Why wasn't it the apprentice stroke trainee, the office junior or whatever? Fine, he justifies what he was doing there. The taxi master says, no, we're only giving you 2 hours and we're giving you the apprentice's rate. All of that takes a huge amount of time to conduct that inquest. Result, they've all started mediating. I've done one of them, but between cost accountants, it's usually a cost accountant who try and mediate or arbitrate the costs because it's cheaper and you save the stamp duty anyway. And the fee for a mediator or an arbitrator will be cheaper than the stamp duty. Again, the usual rule will apply. In other words, Order 99 scenario, the winner gets their costs. But the court can take into account conduct before and during the proceedings, and that one of the parties was or were unreasonable in refusing to engage in settlement discussions or in mediation. And that's where your paper trail is going to be called important. You invite people to discuss settlement. Even if they have from the outside said, full defence, no question of negotiations. Invite them. Have the paper trail to show that you are willing to engage. Because if it's a on an objective basis, assessed by the court as being an unreasonable refusal to talk, to discuss, to meet for settlement, or to mediate, negotiate, arbitrate, ruminate, cogitate, defecate, any age you want. If they're unreasonable, they can be denied their costs, even if they win. Equally, in exceptional circumstances, and it is exceptional, the court can not only deny a party their costs, but even if they were successful, order that they pay the other side's costs. If the court forms the view that they could have achieved the result they got without litigation. And that's the summation of the 100 slides that I might have went back into. The Act itself, this is the main bit of the job done. I know you're all intimately familiar with the process of enactment of legislation, and that when a bill is passed by the House of the Oireachtas, a courier takes it out to the park, and within 5 days the President must sign it off. I knew that as well, so the minute the courier left, I got into the office of the President and I asked for something that I had never heard of happening. You know the way Donald Trump has a big signing ceremony, and the pen becomes a treasured object, particularly if you're a member of the NRA. Now, it wasn't that I wanted the pen, but I got into the office of the President and I said, look, I'm very interested in mediation. My head is so big, I've got 3 hats. Chairman of the Chartered Institute of Arbitrators, ADR Committee, and the Mediators Institute over on the other side. Can I come and watch the President sign the bill into law? I paraphrased the response was, Jesus, no one has ever asked something like that before. And I got a very nice note from somebody in the park, in personal handwriting, saying, unprecedented, unheard of, no protocol, don't know what the procedure is, not going to settle this to the President now, might think about it for the future, but consolation prize, you will get a call the day that the bill is signed. 6:10 on the 2nd of October 2017, Secretary to the President sent me a text, the bill was signed at 16:05. So I was first out with a tweet to say that the bill became law. They can put that on my tombstone, whoopee. Now, we're then to what the Act is all about. That, it breaks down into roughly those sections. Preliminary general, mediation general, the bit you're really interested in, what have you got to do with the obligations, the role of the court in mediation, etc. Definitions, classical section 2, what is it? It's a confidential, voluntary process where parties, with the assistance of a mediator, because the parties have to come up with the result, it's not a mediator deciding anything like an adjudicator or an arbitrator. You don't decide anything. You listen to people, you make sure that they feel that they have been heard, you communicate the issue to the other side. Sometimes you have to translate the message. I was doing mediation on Monday in Dublin, and a senior counsel who was a bit rough around the edges, is the best way I could describe him, said, you go off and do your job now, laddie, quote unquote, and you tell them feckers in the other room. So I translated the message suitably and delivering said message. But you try and assist people to get to a mutually acceptable agreement. The mediator, someone who's appointed under an agreement in writing. Now I'll give you a whole pack of materials when the thing is over, and included that is my standard agreement to mediate. It runs to about 8 or 9 pages, and you might say with the name of God what goes on for 8 or 9 pages, but you'll see why if you start reading the Act and the agreement itself. But the agreement to mediate has to be in writing, and it's done, usually you have everything signed off in advance. Now Monday's mediation, we had a signing ceremony with literally everybody in the room, the lawyers, witnesses, parties, you name it, signs off on it. It's usually all agreed in advance, but the clock for the statute of limitations stops the moment the agreement is signed, which for most mediations is in the morning that it's starting, and it ends when the settlement is signed. And unfortunately my record slipped on Monday because we didn't get a settlement, the one on Monday. Either when a settlement is signed or 30 days after the mediation ends, and the mediator has a statutory obligation to notify the parties that the 30 days runs from a given point in time. And you have to try and reduce all of that to writing. What the Act does not do, it does not define what it applies to. It defines what it doesn't apply to. So by inference, everything that it says it doesn't apply to, does apply to. That said, it doesn't apply to anything capable of coming under the Workplace Relations. For example, a claim that could go to the Workplace Relations Commission, the Act doesn't apply to it. That's not to say you can't mediate it, but it's not a mediation under the Act. I told you it was so simple a lawyer can't make it complicated. It doesn't set out any training or accreditation standards. Like architects, up to a number of years ago, anybody could call themselves an architect, anybody can call themselves an accredited mediator. Now here's the good bit of news for you. John will arrange for you all to get a CPD cert for coming here today, but I now pronounce you all accredited mediators. You're all accredited by the Church of Bill. What's that worth in marketing terms? Bugger all. But that's the position at the moment. It will come, like the architects, they will set standards, but not at the moment. It doesn't give any group a role. It was envisaged for a long time that the Mediators Institute would become the regulator, but the Institute itself wants to stay as a trade union, so to speak, like the Law Society and the regulator. There's a suggestion that they'll make the provision of mediation services legal services, they'll define it as such and bring it in under the regulator, because they want to have provisions for complaints against mediators, etc. Doesn't put any funding towards it, because there's a residual provision for a mediation council, who's going to pay for the hotel, the sandwiches, this cup of soup, etc. So, the original wording of the bill when it came out talked about civil proceedings, and it was only apply to something that was already in court, but it was then amended to say any dispute, because things can be mediated before, during, or even after litigation. You could have, and I've had a case where I mediated between a High Court judgment and a pending appeal in the Court of Appeal, and it was successfully mediated. Doesn't apply to the workplace relations, doesn't apply to revenue. We all know the revenue don't negotiate, the revenue don't arbitrate, the revenue don't adjudicate, the revenue arrive at a position where they feel they're happy. You might not be happy, or you might be happy, but the important bit in the equation is the revenue are happy. Equally, it doesn't apply to arbitration. It doesn't apply to any determinative process, like adjudication or arbitration. It doesn't apply to anything, childcare, domestic violence, anything where the concerns of vulnerable people are at issue. Section 6, it's a voluntary process. They can come in and out at any time. With that said, I say to people at the group hug, again, that's the media for those who joined late, that's the get together at the start. If you're going to leave, fine, but let's talk about it before you do. Not like Brian, who slapped down the stuff and took a hike. Parties can be assisted by a person of their choice. I had one mediation where it was all about the numbers. There was no real legal issues involved, and it was the accountants who came out with the mediation. Equally, I had a run, as part of the training exercise when I was doing the training, I went to the UK. Now, you saw earlier all the merit badges I collected. First of all, I did CEDAR, and there were 26 of us did the training course in Cork. Very high failure rate for CEDAR, very high standards. And when we got to do an assessment of it at the end, and parties are scripted to play a role, and you then have to try and mediate. It's only 2 hours, it's not a full day, it's not realistic in that sense. But you know the phenomenon where they're €500 apart, and you say, for God's sake, I'll take it out with the fee to close the gap, just get the file closed, get the fee in, particularly if it's in total. You don't do that as a mediator. And the parties were scripted to go there and to stay there and not to bridge the gap. And despite all encouragement, you're so close, would you not even split the difference? And you know, in one-to-one you might say, well, would you be the generous one? Would you take the moral high ground and you give the... No. And I made the lawyer's mistake of suggesting this split it down the middle. You failed. So I went off to London, did it the second time round. The family had a week in London, got it the second time round because I was much more careful. I switched off the lawyer brain and put on the mediator's brain. I was then very involved in the Chartered Institute, so I went off and I collected that merit badge as well, and then the Mediators Institute. But I went to Reading as a deputy doc just to get some kind of experience of a high value mediation. And this was a £6.5 million claim by a landlord against a former tenant whom they said had not maintained the property, had left it in dog order, and they had to beef it up. The defence was fraud, and an accountant did the defence on his own. No client there, nobody else. And he did a fantastic job in completely demolishing the claim. And he showed with a forensic accountant, spreadsheets, Excel spreadsheets, great beauty, change a figure, everything else changed. He showed the figures didn't add up. And he said, I'm speculating, but what somebody did here was took an Excel spreadsheet, converted it to Word, changed the figures, and then PDF'd it. And that's why the figures don't add up. Claim settled at about 5 o'clock in the evening, down from £6.5 million claim, settled for €630,000, pound sterling. We spent the next 3 hours arguing over the costs, finally signed off about 9:30, went for a bite to eat. Just handed back the menus. Who walks in? The accountant. So the mediator from Scotland by the name of Anthony Blasdale said, "Go on, join us. If the other side come in, they can join us as well. It's all over and done. No question of improper conduct or bias or anything." Your man insisted on buying us dinner. The reason being, he was on a percentage of what he saved. Now, he saved 6 million. Do you want to hazard a guess what his percentage was? 20%. It explained why he had property in Jersey, another one in Channel Islands, another one in Florida, etc. Did about 6 of these cases a year. Very high value stuff. But that is gratitude curve billing, where you can get 20% to 6 million for a client. Agreements to mediate must be in writing, must set down the way it's to be conducted, must set down costs and fees, and it's usually split down the middle. I got a letter in the other day, as a result of a visit to Horse and Jockey. Some of the Horse and Jockey suggested me to the state to mediate a dispute with the state, and sent a letter. Here's the letter confirming the state have agreed through the Office of the Chief State Solicitor that you should mediate it, and that the state will pay for it. Now, I've already written back saying the Act says it should be equal unless otherwise stipulated. So yes, the state can pick up the tab, but I would prefer if both sides pay it equally going into it. It may be an agreed outcome that one side picks up the tab, but going into it should be equally, lest there be any suggestion that I'm subconsciously influenced by the fact that one party is paying me. And in one case previously, when I said that, I'm quite convinced that one half the fee was sent from one office, the other to be sent on to me, so that I theoretically and Jesuitically was paid split and split. Must say it's confidential, must set out the right to seek legal advice at any stage. Before Christmas, I did mediation up the west for 2 health professionals. The way these health professionals work, they have an associate, but the associate is actually an independent contractor, not an employee. Basically, they're given a room in which they can carry on their practice, and they pay for the facilities, and they pay for a percentage of the fees that they get by the use of the hall, so to speak. That's the way it works. Taxman looks at it very carefully, but for the moment, that's the way it works. The associate bought out the principal, bought out the practice. They also bought the premises, and for some reason that I didn't get into, the conveyancing process took 2 years. The week after the sale closed, the new principal, former associate, as she was entitled to do under the contract, terminated the contract. The former principal, now associate, very aggrieved. There was a restraint of trade clause in the agreement. This is a West of Ireland town, and there were 2 females as it happened, which she said, "Am I now to be denied the right to carry on practice in the town in which I've lived and practiced for the past 35 years? And for a year, I cannot, in a radius of 15 miles, I cannot practice. This is unfair." She signed up to it, it was in the agreement, it was a commercial term, etc. Both contacted the representative body for these type of health professionals on the same day looking for help. They both contacted the same person. That person said, "Would you not mediate?" Got on to me, asked would I mediate. I said yes. The names of the parties were sent on to me, and I said stop the lights. Now, I grew up in Bishopstown on the west side of Cork City, even though the fact is, even though I'm known as a Corkman, I was born in Limerick. My father worked in Shannon, don't blame him, it wasn't his fault, he was sent there. But it suits me when I cross the county bounds into Limerick to declare I'm a Mayorstone Park boy. But I said, I think, given the nature of the identity of the health professional involved and the name, I think one of them was a next door neighbour of mine in Cork 40 years ago. That may disqualify me. Now, the other party was actually so impressed that it declared the fact that someone who was in their teens when they left Cork, having lived next door to me 40 years ago, that they said, not a bother. And besides, you're not deciding anything, you're a mediator, not an adjudicator or an arbitrator. Went up. Now, you have somebody who's now saying, I paid for the practice, I bought the practice, I paid for the building. Part of that price was she had to give up when the agreement was terminated. Other side, very aggrieved, 35 years, Got into it. One of the issues which came out was the fact that all of this happened the week after the former principal, now associate, the week after her mother had died. Timing for her could now have been worse. But in the course of talking to her, and you have to be a bit of a psychologist, psychotherapist, counsellor and otherwise as a mediator, I got her to understand she wasn't actually grieving for the practice. She had been handsomely paid. In fact, I was astonished by what was paid for the practice and for the building. But I didn't say that. She was grieving for her mother, but she had fixated on this issue as a coping mechanism for trying to cope with the grief of her mother's death. And when she realised that, naturally there were tears, but suddenly she didn't care about practicing. It's the reason she had so much practice was she wanted to spend more time riding horses and spend time with a new grandchild. So she didn't actually care about practice at all. Equally, she accepted that for the previous 10 years she'd only been practicing part-time anyway. That unlocked that bit. Equally, the former associate, now principal, said, look, I'm not worried. She hasn't practiced for the past 10 years. If she sat next to me in the morning, I don't think anybody would necessarily go to her. So I'm not worried. End of, we did actually have a hug. I'm not saying it was because there were two females involved, but the end result was a settlement and there was a hug. Only case I've ever mediated where the parties hugged each other at the end. There was lots of tears too, by the way. I'm not suggesting that it's a sexist thing because of females, but that was the way it was. Mediators' obligations. You must set out all the merit badges you have in terms of qualifications. You must act with impartiality. You must give details of your experience, how many cases you've done. And the problem is mediation is confidential, so you can give numbers, but no one, I can say I've done 6,000. Who the hell knows? Because you've no way of checking it. I can say I've done mediation of space race disputes. Who knows? Because you can't, confidentiality would preclude you from telling. But for what it's worth, you have to do that. And treat parties fairly. You must, as I said, give details of your qualifications and courtesy of the master. I can now say the master of at least one. That's the trophy wall as I describe it. You may make proposals. If you get to a point where they're within 500 quid of each other and they're not doing the deal, you can agree at the request of the parties to stop the mediation process and become a conciliator. Now it's very important as a mediator that there's a formal recognition. There's no hope of bridging this gap. We're now agreeing to shut down this process. There's no going back. You now want me to make proposals to bridge the gap between you. That means I'm stopping acting as a mediator. This is a very serious, no re-enter door. It's a one-way door. Once people understand that and they invite you to do it, you can then make proposals to them. They may offer you 2 fingers as a result. You may go away. You again have a non-success on your record, but that's their choice, and it has to be their choice. You must make every effort to minimise costs. Back to the mediation where the mediator shut down the sulky bus after 2 hours. He was paid for the day. He happened to be a senior counsel. Now, senior counsel, by the way, in my experience, do not make the best mediators. There's a handful of them who are very, very good, and some of them who make their living at it. That is mediating. But generally speaking, senior counsel are negotiators, and they approach it from the wrong angle. I'm not suggesting it has to be me. If you're going to mediate disputes, find a good mediator. The difficulty, of course, is because everything is confidential, and you don't get to see somebody perform in the way you would in court. You don't know, you have to make inquiries, you have to work on the basis of, does somebody know any good mediator? Like I said, I can tell you I'm brilliant. The only way you're going to find that out and warn everybody else in Kerry is if somebody asked me to mediate something. But you must make every reasonable effort. The mediator paid for the day, shut it down after 2 hours, was back in his office by 11 o'clock, and he returned 2/3 of the fee. This was before the Act, didn't have to do it, but again was very fair about it. If you're going to withdraw as a mediator, you must give out reasons for it. You can't make the fees contingent on the outcome, and you must manage any conflicts of interest, even if they arise. You might discover something in the course of the mediation which gives rise to a conflict. And if that happens, you might have to manage it. That might include stepping out of the process. Costs to be shared equally unless otherwise provided. Codes of practice. The department is inviting lots of submissions at the moment, and they're ruminating, cogitating, and they may defecate in due course in relation to procedures. But they will look at standards, confidentiality, redress procedures, and those complaint procedures for people who there might be dodgy. Because at the moment, anybody can, one of you can walk out today, say, I'm an accredited mediator, Bill Holohan accredited me today, set up with a big plaque in the morning, launch an advertising campaign on Radio Kerry, and a Kerry man, getting loads of work and making absolute bags out of it because you haven't been trained for it, and then somebody wants to complain you. Who did they complain to? Joe Duffy will listen, but probably nobody else. Section 10, everything is confidential. The mediator is entitled to develop amnesia, except for reporting obligations to the court, where the mediation comes out of court and it has to go back to court with a report. If it doesn't come out of court proceedings, if it's pre-court, there's no obligation to give a report to court. And in those circumstances, literally, you're entitled to develop legislative, sanctioned amnesia when the whole thing is over. There are exceptions to that for childcare if there's issues in relation to potential criminal offences or danger to children or danger to vulnerable persons. You're entitled to breach the confidentiality in those circumstances. Story with third parties. Lawyers owe a duty of confidentiality to their clients. They owe none to a mediator. Hence, as I described on Monday, everybody in the room had to sign up. Now, one of the parties was a big multinational company. They were represented by one of the Glass Palace firms, and I was quite surprised that the lawyer representing them didn't seem to have done a mediation before. I didn't embarrass her by asking her the question, had she ever done it? Because when we were going through the mediation agreement, we spent 2 hours reading the mediation agreement over the phone, and every line and every comma, and should we have a comma there, I felt it was padding the fees for the international client, but it's another day's work. And I didn't see the need for me to be involved in that. But it came down, and I got a John McEnroe response to the bit at the end, that the lawyers, senior, junior, trainees, everybody had to sign off. And I got a bit of a, you cannot be serious. And I said, absolutely. I said, ye owe me no duty of confidentiality. There is a statutory duty now under the Section 10 of the Act, but this is providing a statutory or a contractual basis for confidentiality. Now, there's a method in my madness, and I'll explain it about the mediator's report when I come back, because the last thing I want to find is that I'm subpoenaed to court or served with a notice to cross-examine on an affidavit, and I'm questioned about what I've done with mediation. A bit like your man Kelly in the 70s, those of you who are old enough to remember, who wouldn't identify Jerry Adams on a tape and went to jail for it, and I have no ambitions to even be asked the question whether I'm going to reveal something. Enforceability of agreements under section of the Act, it says the parties must determine if and when agreement has been reached. So if the parties decide to settle and they decide whether the terms are to be a legally binding settlement, you go to the courthouse in Tralee or anywhere else and you settle a PI case or whatever it is, and you reduce it to writing, you sign it off, that is a contract which is legally binding. It falls apart, you might go back and say, no, we'll go back to the original proceedings because they're better in terms of the potential return, or we'll sue on the settlement. With this, you can reach an agreement, but it can be provided specifically that it's not legally enforceable. It's a gentleman or gentleman's agreement. Up to the parties to decide. The default provision, no, I need more water. The default provision is that it is legally enforceable. Then the Mediation Council, a possible body. It's basically to promote awareness, develop standards, codes, be the regulator, etc. As I said, there's an idea that they might actually provide a council, but the regulator might become the legal services regulator. The main event, Section 14 and Section 15, solicitors and barristers' obligations. Now, the reason barristers have an obligation is because of direct access provision. If somebody goes directly to a barrister for advice, the barrister has equal obligations to the solicitor under Section 15. The solicitors are under Section 14. And what you must do is you must advise the client to consider mediation. A statutory obligation to do it. You must provide the client with information in relation to mediation services, including the names and addresses of people. Now, I will give you a pack, and I developed this pack because sometimes I get a phone call from solicitors, and you can tell within about 60 seconds whether they've ever mediated before. And I said, look, I'll tell you what I'll do. I'll give you a pack of information that you can give to the client, which will save you time in explaining to the client what mediation is, how to spell it, what it's all about, how it works, the advantages, the benefits, except the cost savings, etc. And I know they're all going to be reading it before they ever give it to the client, which is fine. But you could take that pack, give it to the client, and tick most of the boxes on the checklist that I'm going to give you later on as well. The bit you can't tick off is you must do it in multiple terms. You must give names, plural, and addresses, plural. It would be great if I was the only person whose information has been circulated by every system in the country, but you can't do that. You have to pick somebody other than me as well. You must outline the advantages in the context of the particular case. Now, you're entitled, if you've got the Kitchen Island case or the Tower Starlet case, that I've explained earlier to say, look, the costs are disproportionate. In these circumstances, I don't see any particular advantages. I don't see any. There's a benefit, yes, but there's not an advantage. Therefore, I don't think you should incur the expense of going to mediation. That might be fair enough. You must then swear a statutory declaration that you've done all this. So you have to write to them, you have to tell them in writing, and you have to swear that you've done it. Now, the problem is, when the whole thing goes completely backwards, head over heels, and the client finds not only are they not getting their costs, or worse, they have to pay the other side's costs, and they say, you never advised me. Oh yes, I did, I have a letter on file. I never got it. So what do? You do a short one-pager, and you make it up a standard form. I confirm that you have advised me in the circumstances of case Joe Bloggs versus Josephine Kelly, or whatever it is, about the advantages, the benefits, the cost savings. You have provided me with the following information: Bill Holohan's information pack, links to websites, names and addresses, etc., and you get them to sign it. The reason being, when they do make that complaint, or they deny having got it, you go na to them, you produce it to the Law Society when the complaint goes to the Law Society, and you produce it to your insurance company when they sue you for negligence. Right? That's your insurance policy in terms of practice and procedure. Bernard P. Conan finds Limerick. Anybody know him? Yeah. He was up in Limerick when I went to talk to him in Limerick. Now, Bernard I know of old because he, in the good old days before they put the limit for bankruptcy summonses up to 20 grand, Bernard would go in for 20 euros. And he found it was a great debt collection mechanism on the basis that bankruptcy summons would concentrate the money wonderfully and people would focus and respond. But he said to me, I issued proceedings last week against a client for fees. And I said, did you issue them in your firm name or did you issue them as Bernard P. Conan, an honest, upright man? He said, I issued them in the firm name. And I said, I'm sorry, no, Bernard. Under the Act, you as the solicitor must now write to yourself as the client to advise yourself about the benefits, and then swear a declaration that you have advised yourself. I said, it's nonsense, but that's a statutory requirement. Now, when they started drafting the rules as well, by the way, you had to have the declaration before you could issue proceedings, but a couple of people like myself pointed out what about, where you get the phone call, but the client hasn't been into you, you haven't had a chance to advise, you're running down 4:15 to the courthouse to get the proceedings issued. And he said, okay, you can issue, but before you do anything further, you have to put in the Section 14 declaration. Before you file for judgment to default, before you bring a motion, before you do anything, you have to file the declaration. And that's a statutory obligation. When the bill was being discussed at the head stage, a number of us went to the Oireachtas Committee. Now, they didn't invite the Law Society in, they didn't invite the Bar Council in, they invited all the mediation bodies, and every single mediation body sent along the lawyers. So we got there anyway. And we made the point that it shouldn't be the lawyers doing this, it should be the clients. And that the clients should say, yes, I have been advised by my solicitor about the benefits. Yes, I've been told about the advantages. No, I'm not going there, and at least not now, and here's the